They're going to bring their operations home. Didn't I tell you that? Well, look at California right now. Look at Los Angeles. What else do you think that is besides violent colonization turning inward? You think this is about immigration law? You think ICE is enforcing laws? No. They are marauders and you are the loot. ICE is not a law enforcement agency. It is a mercenary force under contract to private corporations, hunting human beings for profit. That's all it is. They work for the private prison industry. Your so-called immigration department is just a subsidiary. It's an interface for the private prison industry. That's what it is. That's what you turned it into. Every detention is a paycheck. Every deportation is a dividend. Do you understand? They're not police. They're pirates. They're pillagers. This isn't policy. This is commerce. It means they're going after immigrants now. This is a pilot project. They normalize it by targeting immigrants, but this is a profit-making endeavor. And you'd have to be crazy to think that they're not going to multiply their revenue streams by targeting other demographics. Does Amazon care what's in the box? No, neither does ICE. They don't care what's in the box. You're not a person, you're inventory. Now you may think, well, I'm not undocumented, so this isn't my problem. Wrong. Because this isn't just about who's being deported, it's about why this is being done the way it's being done in the first place. It's about who's in line next time when the migrants are not enough to satisfy the profit potential of their model. They don't protect communities, they invade communities and steal people. Where have we seen that before? Corporate contractors like Geo Group, like CoreCivic. They're making billions of dollars from these cages, from this trauma, from this misery, from this terror. This is modern slavery packaged as homeland security.
ICE, U.S. Immigration and Customs Enforcement, and its connection to issues that resemble modern-day slavery, especially in how it detains and uses immigrant labor under the oversight of Homeland Security. Here's a clear breakdown. What ICE is a federal agency under the Department of Homeland Security, DHS. It was created in 2003 after 9/11 to enforce immigration laws, investigate human trafficking, and handle issues related to national security and customs violations. Why people compare ICE to modern slavery? Many activists, journalists, and human rights organizations argue that ICE's detention system mirrors modern slavery in several ways. 1. Forced or exploitative labor in detention centers. Immigrants held in ICE facilities are often made to work for as little as $1 a day, cleaning, cooking, or maintaining the facilities. Lawsuits have alleged that this violates the Trafficking Victims Protection Act, which prohibits forced labor. Some private prison companies profit heavily from this system. 2. Profit-driven detention industry. Most ICE detention centers are run by private corporations like Geo Group and CoreCivic. The more people detained, the more profit they make, creating a financial incentive to keep detention rates high. 3. Separation of families and psychological trauma. The inhumane conditions, including family separation, poor health care, and indefinite detention, have been condemned by human rights groups as cruel and degrading. 4. Fear and control. ICE's raids and surveillance tactics often instill fear in immigrant communities, discouraging people from reporting crimes or seeking help, a form of social control that echoes historical systems of oppression. Homeland Security's role. Since ICE is part of DHS, it operates under the broader umbrella of national security. Critics say this framing allows inhumane treatment to be justified as a security measure, making it harder to hold the agency accountable for human rights violations. In summary, yes, when people say ICE is modern slavery packaged as Homeland Security, they're expressing the idea that, open quote, the U.S. government is using the language of national security to disguise a system of
mass detention, forced labor, and profit that echoes slavery's legacy.
Here are a few excerpts and summaries from court filings, complaints, and legal analysis showing how detainees and their lawyers articulate forced labor coercion claims, including what they argue makes labor forced under the law. Key documents and their arguments. 1. Novoa v. Geo Group, third amended complaint, Adelanto, California, this is one of the leading cases in which immigrant detainees asserted that work programs in ICE contracted facilities amount to forced labor. Deportation Research Clinic. Major allegations in that complaint include: GEO secures free detainee labor at nearly all of its civil immigration detention centers nationwide through systematic threats of serious harm. Deportation Research Clinic. Detainees are required to perform tasks such as cooking, cleaning, facility maintenance, and other internal operations. Deportation Research Clinic. The complaint argues that GEO's practices are not truly voluntary. Detainees face punishment or adverse consequences if they refuse to work, e.g., loss of privileges, disciplinary segregation. ACLU Washington. The complaint also challenges a housing unit sanitation policy, under which detainees are required to clean their housing units, e.g., cell blocks, toilets, without compensation. Clearinghouse. It frames the work program as replacing what GEO would otherwise need to hire regular staff to perform, thus capturing cost savings as unlawful labor cost reductions. Deportation Research Clinic. The plaintiffs assert causes of action under California and possibly other state minimum wage laws. The Trafficking Victims Protection Act, TVPA, which prohibits obtaining labor through force, threats, or coercion. Involuntary servitude, Georgetown law, Tasharp 2, State of Washington v. GEO Group, Washington complaint. The State of Washington Attorney General also filed a case against GEO over conditions at the Northwest Detention Center, Tacoma, seeking to enforce the state's minimum wage laws. AG Portal. From the complaint, GEO pays detainees $1 per day for the work they perform at the NWDC. The complaint alleges this violates Washington's minimum wage laws. AG Portal. It claims GEO's failure to pay proper wages results in unjust enrichment. The complaint also states that GEO's federal contract with ICE requires it to comply with all applicable federal, state, and local laws and codes, including labor laws and codes, implying GEO cannot ignore state wage laws just because it's a contractor for ICE. 3. Plaintiff's second amended complaint. Washington detainee case, 38CV05139BHS. This complaint from detainees in the Washington facility provides more allegations about daily life and the labor practices. It references the $1 per day wage for detainees. JSIS. It claims detainees raised issues like the quality of food and adequacy of pay via internal grievances, suggesting complaints were made internally. JSIS. It notes that ICE authorizes placement in disciplinary segregation, which plaintiffs argue can be used as a coercive threat if detainees do not comply with facility rules, including work assignments. ACLU Washington. Legal theories and statutes. Trafficking Victims Protection Act, TVPA. Forced labor provision. The TVPA has been used in several of these lawsuits. Under 18 U.S.C. Tashkari 1589, forced labor is defined as labor or services obtained or maintained by means of threats of serious harm, penalty, physical restraint, abuse of law or legal process, or other methods of coercion. Georgetown law, legal analyses argue that ICE, private detention companies, might be liable under the TVPA because detainees are in a vulnerable position and often powerless to resist. University of Chicago Law Review, state minimum wage and labor laws. The Washington case and others argue that detainees should be paid at least the state minimum wage for work performed. The Washington case has resulted in a jury verdict awarding $17.3 million in back wages plus additional penalties. Washington State Standard. Courts and state officials have considered whether ICE contractors are required to obey state labor laws, even though they operate under federal contracts. Deportation Research Clinic. Hashtag how courts have responded. Challenges. Employee status. One major hurdle is whether detainees qualify as employees under state labor law. Defendants often argue that detainees are not in a traditional employer-employee relationship because the work is part of confinement. Washington courts. Voluntariness argument. Defendants contend work programs are voluntary and that detainees may opt out without serious repercussions. Plaintiffs dispute this, saying opting out carries real penalties, loss of privileges, disciplinary measures. Deportation Research Clinic. Federal immunity, supremacy. Some defenses claim that because GEO is operating under a federal contract, state laws like minimum wage statutes cannot apply or cannot be enforced, federal preemption. Courts have rejected some of these arguments, e.g., A Ninth Circuit ruling affirmed that GO must comply with Washington's minimum wage statute and cannot claim immunity simply because it is a contractor. Ninth Circuit Court of Appeals. Distinction between civil versus criminal detention. Some courts emphasize detainees are held in civil immigration detention while their status is decided, not criminal punishment, which can affect analyses of what kinds of labor they may be compelled to perform. Ninth Circuit Court of Appeals.